Welcome to this webinar on arbitration M&A disputes, tips and tactics. I'm Andrew Judkins. I practice as a disputes counsellor in Norton Rose Fulbright. In this webinar, we're going to cover, firstly, a refresher on the types of M&A disputes, key differences between litigation and arbitration relevant to M&A disputes, preliminary matters in M&A arbitration, document production, factual witnesses, expert witnesses, interim applications, and parallel proceedings. M&A disputes are an increasingly significant proportion of arbitrations before the major arbitration centres. Increasingly, the contractual documents used in M&A transactions have arbitration clauses rather than court jurisdiction clauses. This is particularly the case in relation to cross-border M&A. English law transaction documents, of course, very frequently relate to cross-border transactions. In terms of the trends and frequency of M&A disputes, they naturally tend to follow hot periods of M&A activity. Many M&A disputes arose out of the post-COVID M&A boom in 2021. M&A disputes can be divided into pre-closing or post-closing disputes. In arbitration, most disputes are post-closing. Parties to an M&A transaction usually do not result to arbitration before the transaction has even completed, although it can happen. Let's briefly talk about some common types of M&A disputes. Completion disputes. This is a dispute about whether the conditions for completion, i.e. conditions precedent such as regulatory approvals, have been satisfied. This is a type of pre-closing dispute. It usually arises in circumstances where one party, usually the buyer, wants to get out of the deal. There may be a dispute about whether a break fee applies or whether the buyer can be forced to complete under the transaction documentation, i.e. by specific performance. Breach of covenants. This type of claim can be either pre- or post-closing. Typically, a sale agreement will provide that the seller must maintain the value of the target company between signing and completion. These are called interim covenants and can be particularly significant if there is a long period between signing and completion. Disputes may arise when the buyer considers that the target company has lost value during that period, e.g. due to the loss of a key customer contract or deterioration in the company's financial performance prior to completion. There is very often a dispute about the extent to which this is caused by breach of the covenants or by events outside the seller or target company's control. Warranty claims. This is one of the most well-known types of claims. It's a post-closing claim. Warranty claims arise when the buyer alleges that the seller has breached the warranties, or in more US-style language, representations provided in the sale agreement. Warranties are contractual provisions given by the seller. The scope is negotiated, but usually includes aspects of the condition of the target company, such as warranties as to the accuracy of the financial statements, accounts warranties, and in relation to material litigation.